A21-844652C, Anne Marie Echevarria versus Zaon Collins. Can I have counsel make their appearances, please?
Good morning, Your Honor. Michael Nixon, 12839, Plaintiff.
Good morning, Your Honor. Walt Cannon, bar number 1505 on behalf of Mr. Collins, and I should apologize in advance. I was not aware of the court's preference that we be on video for this hearing, and I apologize, and in the future I will make sure I will be before a video machine to get me in.
Okay, thank you very much. Okay, so I had counsel appear in this matter about a week ago, and part of the problem was Mr. Durrani, I think, was counsel for defendant that was here, was unable to discuss exactly what could and couldn't be done in discovery. And I am holding a minute order from, I want to say, Judge Barker, who did stay the case, but only as to the deposition of the defendant. So last week when you all appeared, I was informed that discovery responses had not yet been sent, even though I think discovery requests were sent out back in April. Was that the correct date? April of 2022, I think.
I don't recall the date specifically, Your Honor, but discovery requests have been sent, and only the RFAs have been responded to by this date.
And I don't think that any depositions have been taken or anything, if I'm correct with what happened last week. So I asked counsel to come back in 1 week's time with an understanding of what could and couldn't be done in discovery, because something like deposing the plaintiff, I think defense can probably do right now. But Mr. Cannon, I'd love to have you speak to that, to discuss whether or not you think that can be done, and if you don't think that can be done, why you think that is. Because, like I said, the stay I'm looking at is just a limited stay granted by Judge Barker that just allowed a stay on the deposition of the plaintiff, and I think it actually said nothing else. Like, I think, yeah, the case should proceed on everything else. All of the discovery shall proceed, was what Judge Barker wrote. So, Mr. Cannon, can you kind of give me some feedback on that?
I certainly will try, Your Honor. The stay was to Mr. Collins. He's a criminal defendant at this point, and they stayed his deposition. The discovery that was previously served, the only problem that I would have in answering the interrogatories is statements or questions in the interrogatories that are effectively the same. For example, there's 26 interrogatories, and 12 of them deal with the facts of the incident, which is the basis upon which Judge Barker granted the stay with regard to Mr. Collins's deposition. And he's going to be under oath when he answers the request for, or answers the interrogatories, and it's going to have the same effect. So other than that, no depositions have been taken by us of the plaintiff. Number one, I didn't think it was fair to pursue discovery against them before Judge Barker's order, when we were asking that they stay my client's deposition. And for that reason, no, the plaintiff's depositions have not been taken. As far as Judge Barker's order, it came out, as you correctly pointed out, on the 27th of December, but it also said it was going to be revisited once you, or I think at the time it was Judge Schwartz that was going to take the bench. So that kind of delayed us going forward, at least in my mind, further at that point. So now that we have this opportunity, I think we can get all the discovery done in this case from our perspective within 90 to 120 days without any problems. I don't know that there'll be that many witnesses. There are a number of witnesses that have been listed with regard to having knowledge of it, but I think the plaintiff's deposition for the estate, for herself, and for as heir or as guardian ad litem for her son, I don't think that those are going to be protractedly long. And I don't know if that's sufficiently addressed your question, but that's the information I would provide at this point. And if you have any questions, I'll certainly try to answer them.
Okay. Do you want to add anything, Plaintiffs' Counsel, before I ask some questions, Mr.
Yes,
Nixon?
Your Honor. As you know, Your Honor, the stay was issued as a motion after a motion for reconsideration was filed when the original trial judge denied the request for a stay. And as all the attorneys know, if you need to plead the fifth to answer questions during discovery, you can do that. That's an avenue available to every litigant, including the defendant in this particular case. But the fact of the matter is we haven't been able to get even written discovery completed because they've just been sitting on it for the reasons stated by Mr. Cannon just now. We've got no request for production of documents responded to. Any of the interrogatories that they could answer haven't been answered. And so we've been waiting for some considerable amount of time. And unfortunately, the way that we need to do our discovery is that we need to take defendant depositions and do some other discovery into the facts of the case so we can hire the appropriate experts. My office met with Mr. Cannon's office over the past week, and I've been instructed by Mr. Lotta today to request 6 months so that we can get the experts that we need lined up after we get the initial fact depositions and discovery done, so we can actually prosecute our case and build the case that we need to prove our causes of action and claims. And we've been just patiently waiting for the court to allow us to do that, or to have defense counsel just kind of get it done.
Yeah, I mean, what I'm looking at is it looks like the controlling scheduling order had discovery closing.
It's already been, excuse me, I didn't mean to interrupt, but I think if you're referring to the one on 4/27/22, I think it is pretty much, well, short of, all discovery supposed to, on March 7th, 2023, is that the way you read it, Judge?
Yeah, I'm looking at the one that was filed May 20th, and yes, it looks like discovery closes March 7th, and expert deadlines were back in December, but I understand what Plaintiffs' Counsel, Mr. Nixon, is saying, that can't disclose experts if you can't take some depositions. But what I was a little alarming last time you guys came in front of me is nothing's been done. But I get that Barker just had it in December and you were waiting on the stay motion to figure out what was going to happen, but we need to get some discovery done on here and now. Mr. Cannon, you just represented that you thought discovery could be done in 90 to 120 days, leaving out your own client's part of it. Mr. Nixon, you were saying about 6 months, which probably is a little more accurate, I would think, if you've got to disclose experts and everything else. Unless Mr. Cannon already has his experts lined up, that might be possible too. So, I mean, have you talked with one another about taking some of the depositions, like of even the plaintiffs in this case, so that you could start moving on the damages issue? Because, on the damages issue, you can probably still go forward with this stay. And I'm not inclined to completely revisit it unless you guys are giving me some reason why you can't move forward on doing discovery on damages.
I don't have any problem with doing that. And a conference call was set up between myself and Plaintiffs' Counsel on February 13th, but for some reason that call never went through, and I'm not sure why. Maybe there was a conflict. But yeah, I think if we can probably get, if they want 6 months and you're inclined to do it, that's fine with me. And we can reschedule the expert disclosure dates, etc. And I will start taking discovery of the plaintiffs in this. But I would like to get a ruling from you, if possible, with regard to, I know it stayed as to his deposition, but in answering interrogatories, if the questions relate to something concerning the accident, his perception, that type of thing, I believe that would be protected under the stay. And I would like to get your advice on that.
I don't want to give you a preliminary ruling when I'm not actually looking at it, but what I would suggest is that you respond, and if you believe it falls under the stay, you can write that in your response and then have a meeting with Plaintiffs' Counsel, and you guys can discuss if there's a disagreement, and that probably that could possibly end up in front of discovery or in front of me, depending on what the issue is. So I'm happy to revisit it that way. What I would say, though, is get the responses out. Even if you need to say, I believe this is covered under the stay, or my client's on this. I don't know what the exact question is, but it's hard for me to give you an answer to that when I don't have the question sitting in front of me to tell you whether this stay is going to apply to it or not. But what I would say is respond and meet with opposing counsel. I mean, I'm sure plaintiff's counsel will let you know if they got a problem with your response. It sounds like you guys already had a meeting set up. Hopefully you can get another one set up and get some timelines. But I want to set some timelines today anyway, because I don't want this to go any longer with nothing happening. And okay. I'm probably also going to set a follow-up in this case to do a status check on this case to just make sure you guys are actually taking the depots and answering discovery. I'm not trying to control your case. It's not my job to come in and tell any side how to litigate their case. That's what counsel get to do. However, I'm also not going to let the case sit here and have nothing happen on it for months at a time. When we could at least go forward and evaluate the damages here. I'm hoping that plaintiff has produced to you. You guys, initial productions, I'm guessing we're done because we've got a scheduling order in place. So medical providers are known, correct? Okay. And damages, there would have been some assessment of damages in the initial disclosure. That might need to be supplemented depending on what's happened. But this is a death case, correct? So okay.
Yes, it is.
Okay. So let's set some dates and deadlines. So let's move our initial, and there definitely is excusable neglect here because of the situation. So I'm going to do an amended scheduling order and an amended trial setting. And if something happens with the criminal case that requires moving it out, then obviously we'll have that discussion then, but I don't want to sit on this and have nothing happening. So let's talk about dates and deadlines for the initial.
And Your Honor, if I may, before we discuss the dates.
Sure.
One of the things, obviously, that is going to be contingent upon being able to get done what we need to get done is having those facts available for this litigation. So if the 6-month period expires before we can take the deposition or get factual information from the defendant's mouth, whether it's via interrogatories or a deposition, that's still going to hamstring us in getting what we need to do to prove our case as far as liability and the experts related to that particular aspect goes.
Understood. But if we don't move forward with some part of this now, I think it's just going to sit for longer. And I'd like to have you guys start moving on this stuff that you can move on. So I get it, and I'll make a note, and I'll put a special note in the scheduling order. And there will be a note in my case on my notes saying that there's some unique issues in this case because of what's going on. But let's still set some dates and deadlines. How about we look at May for the initial expert disclosure deadline and the last day to file motions to amend pleadings or add parties, with the understanding that there might be some changes in this depending on what happens. So let's look at how about May 30th? Last day to file motion to amend and initial expert disclosures. Does that day, Mr. Cannon, will that work for you too, May 30th?
Yes, Your Honor, it will. Thank you.
Okay, we'll do the rebuttal deadline. Does any side think they're going to need more than 30 days for the rebuttal expert deadline, aside from the issues we've already discussed?
I can't say at this point, Your Honor, that we would need more than 30 days.
Let me give you a little cushion on that. Let's do July 14th for the rebuttal.
Okay.
Rebuttal experts. And I understand that essentially you're very limited on what you can do. However, I want you to just be doing something, and rather than sitting and doing nothing on the case, and then we have to do everything later. Okay, so May 30th for the initial expert deadline, last day to file motion to amend pleadings. July 14th, rebuttal expert deadline. We'll complete discovery for what discovery can be done right now. How about September 15th? And if that needs to be revisited, I understand. Okay. And dispositive motion deadlines for what we can do right now. We'll do that out a little farther too. We'll look at November 15th. We'll do MILs and dispositive motions on the same date right now, both November 15th. And that might change later. I understand a lot of this might change. I just want people, I want movement to happen. I want you to get responses to your discovery, at least what can be responded to. And I want depositions of who can be deposed to take place. So if we're moving everything out to them with dispositive motions November 15th, let's put you on my April 15th, 2024 trial stack. With the understanding that depending on what happens on the criminal, that might be moved. The order I send out, putting you on that April 15th trial stack, will set a trial readiness date, a pretrial conference, a calendar call, a deadline for the pretrial memo. And as I said a moment ago, the dispositive motions and the MILs already have a deadline of November 15th. In this case, too, I just want to follow up with you guys in 30 days. You can both appear on the computer if you want, or you can submit a status check to me. Just say you're working on stuff and you do have some depositions set. And that's what I want to check in with you to make sure that there's depositions that have been set and that those responses to discovery. And actually, let me make it a little longer than 30 days because the responses to discovery. Let's look at 45. What was the date 45 days out that I had?
April 11th.
Okay, so 4/11, 23, 9:30 a.m. Status check on discovery in this matter. And if you two are already working together and getting stuff done, just submit a status report to me saying we're working together, we've got deposition of so-and-so scheduled, I've got responses to, and it doesn't mean that you're agreeing that you have complete responses, but I've got responses to my discovery, just to let me know that something's happening and that we're not just sitting on this and letting it marinate for too long. Okay, are there any questions about that? Mr. Nixon, any questions?
Nothing, Plaintiff, Your Honor.
Mr. Cannon, any questions?
None, Your Honor. Thank you.
Okay, so I'll see you guys back on April 11th at 9:30 a.m. If I do not receive a status report from you before then, letting me know that some discovery is going on in this case.
Thank you.
Okay, thanks. And you should get a amended scheduling order and trial setting order in the next week or two. It should go out. Thanks a lot, counsel. If there's no questions, have a good day.
Thanks, Judge.
Thanks, Judge.